Hello everyone, this is Sachin Samant, your UK immigration lawyer. Today I am going to cover some of the questions. I am trying a different format now since I am at Bareilly Airport. There is no Wi-Fi here for customers, and also my network is not working, so I am unable to go live at this point. I am still in India attending the series of weddings that I am attending. So the wedding in Bareilly is done now, and I am moving to Bengaluru, that's what it is called. I have a flight to Bengaluru. There I'll be attending another wedding. So in between, I thought of answering some of the questions that have been raised through the comment section on our channel. So I will upload this once I have good internet connection, preferably maybe in my hotel or something. Okay, so taking up the question 3 days ago from Vinayak Rudrani, uh, can an asylum seeker apply for human rights while pending the decision of 5 years? So, if you have already applied for asylum and you have not received a decision on your application, then you will have the section 3C leave. Yeah, if you whatever are the reasons, I'm not sure if your application is pending usually, but if you filed it in time, etc., you may have section 3C leave. So you should be able to apply. It really depends on the facts of the case, but most probably you should be able to apply from what information you have given. The second question is from Sri Ram Harish. So you missed the live. Your employer has got a sponsor license. He has one course, and the employer says that is a defined course. So, and you are currently out of the UK in India. What I need to know is that one course sent to me, which is done. Yeah, by looking at the course, you can say that you should at least have access to the course. By looking at it, you should be able to. I think it says something, maybe defined course or something at the top. But what your employer is saying may be right if they have applied for it and they've given some more information about it, then yes, it may be defined. Uh, but remember, if you are trying to apply from India, which is outside the UK, you can use the defined costs, which your employer is right, you can use it. But if you are trying to get any discounting for such, for example, if you make an application with an undefined cost in the UK and you're a student switching, you have certain discounting. You don't have to pay the immigration skills surcharge, etc. So if you're trying to get that, then I think you should go back to the UK and then get an undefined cost and then apply. But if you are not expecting any other discounting, for example, immigration skills charge is one of them, where if students are switching, they do get that, but that's only for switching. If you do an entry clearance application, you may have to pay depending on your job code, SOC code. So yes, so that is the answer. You can apply from India using the defined cost. Very simple. Okay. And the next question is from Chanda Bakshi. I have a query that I am on a PSW visa switching to skilled worker visa. My cost in my cost tier to category is graduate in tier 4 student route. Okay. So my confusion is said they have to pay roughly 1092 as I surcharge. So he asked the employer, are you ready to pay? Yes, because I'm switching from graduate to skilled worker, but I'm not sure my employer paid. I send my email to them but not reply. It's mandatory. Yes, since you are switching from graduate route into a skilled worker, you have to pay immigration sales charge. I have tried it many times. I have applied, and then obviously the caseworking team came back and they asked for the payment. So yes, you have to pay at the time of assignment of the cost to you. The cost fees of I think 239 and the immigration skills charge depending on the term of your visa. You have to pay it upfront when your lawyer is assigning the certificate of sponsorship to you. So they are right. Next question is David Love Janet. I'm on TF4 visa whose course end date on my case was October 23. I did not finish the course. Failed one module. Not able to finish in fall 2023 because of my PRP, my student visa. Okay. Okay, so your question is about switching into the skilled worker visa. Dependents can switch, so your wife can switch. However, so the question is about a student not completing the course of study and he wants to switch to the skilled worker dependent. I think because your wife, so your wife is a dependent now on the student, she can switch to the skilled worker visa. I don't see there is any restriction. Dependents can switch. But if you want to switch yourself from being the main applicant as a student to becoming a dependent, you may have to do an entry clearance application. You may not be allowed because you did not complete your course of study. So that is the answer to your question. Your wife can switch, I think, but you cannot. So you will have to do an entry clearance application, and depending on the timing of your application, the children may be able to switch as well, because if you are in the UK, both the parents should be in the UK. So maybe you will have to do the entry clearance as well. So just time the applications properly. There are some permissions and all required for the children, because if you cannot apply, then the caseworker may come back to you and all of that. Preferably do it through legal representatives. It may be slightly tricky with the children. So they can switch, but there will be some authorization. Your status in the UK may come into play. So that may be an issue with the timing of the application. So the next question is, lawyer, if your employer certificate is revoked and you have booked your appointments before they revoked. So if your so the question is about your employer's certificate is revoked. I don't think certificates are revoked. The sponsor license is usually revoked. I think that's what you mean to say. So it's irrelevant whether you have booked the appointment or not. You will not get the visa. So I think you have booked the appointment for your dependents already before they revoked. And okay, so what should you do for the application not to be refused? So I'm assuming that you are already in the UK on the skilled worker visa. So and your dependents made the application from outside UK, and you are waiting for a decision for them. In the meanwhile, your employer has lost their license. I don't understand. Employer certificate is revoked. So employer cancelled the certificate. Uh, yeah, it really depends. If the home office, if you are asking for, let me think. So yes, it is possible that their applications may be refused. Yeah, they because the home office may, if for example, if for any reason they do get into the certificate of sponsorship and the status of that is revoked, it is highly likely that their application may be refused as well. It's a 50-50 chance. I know they may check it, may not check it. It really depends on the timing and all, but it's a risk to take. I would rather say that they withdraw their application, and then once you switch to a new employer, then they should apply again. That would be a lawyer's suggestion. But yeah, you can continue with that if it does work for you. I cannot guarantee whether that will be a positive decision. So my wife has a partner visa, is planning to have a delivery in India. So will there be any issues if she stays in India more than 6 months? So your wife is on a partner visa. So I'm assuming she's on a dependent visa or a spouse partner visa. British immigration rules. So one of the two. Staying outside the UK. Will there be an issue if she stays in India more than 6 months? If your wife stays more than 6 months and she is on a spouse visa, that is where the 18,600 immigration rules requirement you are meeting, the partner visa, spouse visa, then it doesn't matter those 6 months. But if you are on a, let's say, student visa or a skilled worker visa, and on that basis she is your dependent, a points based system visa, it's called as PBS dependents, then it, it's not an issue per se, but she may not qualify. The more than 6 months period may break her continuity of residence for the 5 year period. So you may qualify for the ILR, but she may not. If she stays for more than 6 months, she may have to further extend her leave to get out of that 6 month more than 6 months of absence. So her period of residence for the 5 year period will start after she returns back to the UK beyond the 6 months. For example, she returns after 8 months, then from that point, her new 5 years count will start. If she is on a PBS dependent visa, that is a skilled worker dependent, tier 2 dependent, anything, any other dependents, points based system. So that's the only effect. It's not, there are no issues with her visa application coming back to the UK. I don't think there is an issue. Only the ILR qualifying period may be delayed. Okay, Eritech, thank you for your time. Just to ask that currently, are there any immigration route for EU citizens settle in the UK apart from spouse visa? For EU citizens, no, there are no. Sorry, the answer is no. There are currently no immigration routes for EU citizens to settle in the UK apart from the spouse visa. For all European nationals, the rules are the same as it is for the rest of the world. So it is UK and Ireland, except UK and Ireland. If you're a citizen of any other country, the rules are the same for you. So the next question is from Hemant Kumar. So your question is, please help me know if a degree from a distance learning university is eligible for NARIC certificate. May- Yeah, I'm not an expert on NARIC English language equivalency, so I would rather say you can Google for ACTIS. I think it's not NARIC anymore, NARIC. It's ACTIS. The name of the body has changed after the Brexit, so it's ECCTIS. That's how you can Google for it. New name for NARIC. You can write to them, you can call them. Their customer service is helpful. It's kind of a service that they sell, so definitely they will help you out. You can give this information to them and check with them if you do qualify for the English language exemption, whether they will assess your English language eligibility. And so yeah, they are the best body to decide on that. I am just a lawyer, I cannot advise on this. Thank you, but speak to them, they are quite helpful. So the next question is Jose Christie. I have passed all the modules but failed in the recitation. Visa expires 26th of January. Okay, what is this? 6th of January 2024. My dissertations is written by January and this will be out in late March. Okay, so you failed your dissertation, so you're going to do a reset on 25th of January. Decision will come in March. So January, February, March, 2 months. So for my purposes, the only thing relevant is date of your BRP expiry is 26th of Jan, and let's say you will get the course completion by 31st of March. Yeah, that is the way. I think I have made another video on how to switch before on graduate route and all. Watch that video. That will detail you the steps and all. So okay, so I think you have watched that video and you have commented, you have asked this question. I think you may be able to follow the steps in that video and be able to do it, but preferably do it through the lawyers and all, because there is the time deadlines are very important. And with the validity of application, it's very important. If you don't time your biometrics appointment, etc., within the 42-day period from the date of application, so the latest you can submit, yes, it is possible. Yeah, on 26th of January latest you submit your application. You defer your biometrics up to 42 days. uh, Make and then so just do all the calculations, watch that video. I think I've done all the dates calculation in that video. It may be possible, yeah, but speak to an immigration lawyer, then it may be able to helpful. It's a very case specific situation. So coming to BSCS, I have an active certificate, will it be okay for UK Sri Lanka visa? I'm from Pakistan, will visa always ask for IELTS active? I'm not sure which type of visa you are applying. Okay, you are applying for skilled worker visa, ACTIS. Yes, if you have the ACTIS certificate, then it should be fine. I think they confirm that two things in the ACTIS certificate. One is that your qualification was delivered in English language, number one. Number two, your level of English. So it may say C1, B1, B2, whatever that is. Usually they say C. I've seen that all. So it has to be over B1. So the certificate from ACTIS has to say that your qualification level is at the English level of B1 or higher. So whatever higher than B1 is fine. Yes, you can use it. You'll also have to submit the same certificates that you submitted to ACTIS to for the evaluation. So along with that certificate, provide the certificate transcripts, whatever you provided to ACTIS, same things upload onto the skilled worker visa when you apply for it. Next one. Okay, so just Rajitha Nair. How much will be the approximate advocate for filing the PSW visa manually? PSW visa manually. Yeah, I think if you go contact our office in the channel, there should be a website link. You can just email us or call the office, and someone will get back to you with the fees information. Yeah, so or you can email to info@visa-solutions.co.uk. It should be in the channel information, or there should be a website link. If once you follow that link, you'll go to the website, and our contact information should be there. So, so the next question is, may I ask, do I legally have to stay in the UK for minimum 6 months a year to apply for settled status? Is it perhaps enough to pay taxes, or do I need to physically in the UK land? Okay. So the question is about EU settlement scheme. So I'm assuming you are having pre-settled status in the UK or you applied for it. I think you should already have it. Yes, you have to stay in the UK physically. That's important. Just paying taxes will not matter. They are going to make it more and more stricter because there is a lot of abuse of the system that Home Office has observed. So yes, the answer to the second part, you need to be physically in the UK for the duration of the stay that you are claiming. Uh, and the first part, have to stay in the UK for minimum 6 months in a year. So the way the rules work is you cannot be out of the UK for more than 6 months. So I would not advise you. It's difficult for me to advise in the affirmative. Rather, it's in the negative. You cannot be outside the UK more than 180 days continuously at any time throughout the 5 year period. That's how it says. So yes, you need to be in the UK for the whole period, and the only periods that are allowed is in any 12-month cycle. You cannot be out for more than 6 months. If you're out for more than 6 months, then it breaks your continuity of residence for the settled status. Is it possible? It is not enough to pay taxes only. You have to be physically resident. And the third part, what about after getting settled status? Depending on whether you are a Swiss national or other EU national, by default it is up to 5 years you would not lose the settled status. So if you go out of the UK for a continuous period of 5 years and then don't return to the UK for 5 years, then you would lose the settled status. So that is the supervening event that they call it. Okay, you can come in 6 months and all that should be fine after getting settled status. So my father, next question. Abdul Qayyum. My father is living in the UK under EU settlement scheme. Can I settle in the UK with my father? I don't know what your age is. I don't know whether you are dependent on your father. There are many factors that affect whether you qualify under the EU settlement scheme or not. So yeah, maybe you should speak to an immigration lawyer. It depends. There are dependency requirements if you are over 18 years of age, etc. So just be mindful of that. Okay, and speak to an immigration lawyer and take the advice. Many of these family permit applications for EU settles for EU under the EU settlement scheme for family permit have been refused. It's a common thing, and Home Office is looking at them quite strictly now. So, how did my so the next question is for what? Maybe my family document starting this Home Office. Okay, so can you advise on that? Yeah, if Home Office is reconsidering the appeal. So the question is about EU settlement scheme appeal. You applied for family permit, which was refused. You appealed the decision, and as a part of the appeal process, one of the steps that is the Home Office will review their decision. So there is a review process before they go forward with the appeal hearing. So in that case, Home Office is there is some distraction. I will wait for 1 minute. Okay. Okay, so I will end this live and continue in the next video. Thank you.